Here we are. Welcome everybody to this session on the lessons from Danske Bank. My name is Steve Kohn. I am a lawyer who represents whistleblowers. It's what I've done exclusively for the last 34 years, since 1984. And an attorney for Mr. Howard Wilkinson, who's been identified as the Danske Bank whistleblower. He was outed against his will by someone, presumably with the Danske Bank, either a current or former employee, since they knew who he was. But for that disclosure, which is a violation of law, I wouldn't be here and you wouldn't know who he was. So we'll try to make the most of it. By way of background, I've represented many whistleblowers in the financial services and banking industry. I've represented numerous whistleblowers in Europe. I have clients in many countries here, and we've been working very hard to demonstrate the extraterritorial application of the U.S. laws. One of my more famous clients was Mr. Bradley Birkenfeld from the UBS Bank, and he was able to obtain an award of $104 million for blowing the whistle. I was a last-minute addition to the conference, mostly because Wilkinson just got outed, so I don't have prepared information like some of the others. I do have my business card here I brought. I did bring some review copies of the handbook, and I highly recommend, and I'll get into this as I can, but I recommend this book. It explains all the laws that would be applicable in Europe. So let's just get started. And just one last point, I am not here in a representational capacity. I'm here in an educational capacity. So the first is to understand Wilkinson, Danske Bank, and the entire legal framework. You have to just start with this quote from Senator Charles Grassley, who's currently the chairman of the U.S. Senate Judiciary Committee. He had a lot of press over the Kavanaugh hearings, but we know him mostly as a whistleblower advocate. And he's been instrumental since 1985 in enacting many of the best U.S. laws. And this is just what he said more recently, and it's very true. Going after waste, fraud, and abuse without whistleblowers is as useful as harvesting acres of corn with a pair of rusty old scissors. I do want to say that, although I don't have a document, the PowerPoint I hope to have distributed. If you don't get it, you can ask me for it. I have linked in here to the laws, to the quotes, to all the information. So this PowerPoint actually becomes a roadmap to the legal protections available to financial whistleblowers or whistleblowers on money laundering worldwide. The second quote, this is from a former Trump administration DOJ official. He's now been nominated for the court. But it's a truism, well understood in the United States, not that well understood in Europe. Because those who commit fraud often hide. I think he should not have used the word often. Fraud is always hidden. No one publicizes their bribes or money laundering. It's a hidden crime. It is unlike murder or theft. If someone's shot, you see the body. But if someone commits a successful bribe, you will never know the payment was made. It's a hidden crime. And our law enforcement agencies are very skilled with DNA and other, ballistics in a murder or a robbery, fingerprints. But how do they get to the hidden crimes? And the hidden crimes, the more hidden, the better. So as this former acting assistant attorney general says, they hide their misconduct from the public, and the whistleblowers are, he uses the word often, but cut that out, are essential to uncovering the truth. And that is the predicate of all the new U.S. whistleblower laws that everyone is like, what's going on? They're paying millions in rewards. They're doing all types of crazy things in the United States. It's all because someone figured it out that the only way to uncover frauds, and I use that word broadly, is by inducing and incentivizing whistleblowers to come forward. If you do not have an active and successful whistleblower program, the overwhelming majority of frauds and bribes and money laundering will remain hidden. So let's just see a little bit in the Danske Bank case, and we can almost presume that Mr. Wilkinson has a very strict contractual obligation not to say a word to anyone about anything. Of course, I can't confirm that because most non-disclosure agreements themselves are confidential. So you can't tell anybody you've been gagged. But assuming that's the case, and I'm not confirming it here, Danske Bank did confirm exactly what Grassley and the Trump administration officials said. It was a whistleblower who made the bank realize that the AML procedures manifestly insufficient, inadequate, and that all 3 lines of defense had failed. Well, you know, I wasn't there, but I would be in shock if all 3 lines of defense had failed. I just think people were afraid to speak up. And I know that from my experience that the overwhelming majority of employees will never, ever, ever, ever blow the whistle, period. Anyone who thinks that virtue has hit Wall Street and that banks have somehow seen the light, well, you can pick up my card, something, I don't know. So the bank confirmed, and this is very standard procedure. There's nothing here that I haven't seen literally hundreds and hundreds of times. It's just, this is what happens. The bank conceded in its report, this is a report written by their outside counsel, that the whistleblower in his first disclosure, they just put that in context, it wasn't his job. This was happening outside of his direct lines of authority. He wasn't in compliance. He wasn't part of those 3 lines that all should have been doing their jobs. He just did someone a favor. Well, in his first disclosure, a customer filed false accounts, bingo. The bank knowingly continued to deal with the after they knew the company had committed a crime, bingo. And the bank continued dealing with the company even after it had committed another crime. Well, we kind of now, through the newspapers, we know the situation at Danske was fairly serious. The whistleblower reported to management that one of the suspicious accounts apparently included the Putin family. Well, if you're getting $230 billion out of Russia, I assume you're going to get some of that money. And apparently included the FSB, the Russian Federal Security Service. Well, why not? Just so you know, it's not confirmed, although it's in the bank report. Major deficiencies in control and governance made it possible for the Danske Bank branch in Estonia for criminal activities. We are not talking about the mafia here. We are not talking about some shyster hustling up small change on the street corner. We are talking about a major financial institution for which many people are invested that has mandatory series of controls. But we also see something else, which is typical in pretty much every whistleblower case. Because you wouldn't have a whistleblower if the institution was doing its job. This is typical. The allegations brought forward by the whistleblower were not properly investigated. This is all from the bank's own report, by the way. Bottom line, no reporting to authorities. And that is the rub. Because in my studies and dealing with whistleblowers for years, it's one thing to make an internal report, but it's a very different thing to go to the authorities. The statistics show, although the vast majority will not raise a stink inside, and those who raise a stink, the moment they get any pushback, will shut up. They're just going to do their job. They don't want the trouble. And that very small group that pushes it internally, even in that group, the overwhelming majority will never take the leap and go to the police or the regulators. And that is the fundamental problem. Because guess what? Unless people make these reports, crime is profitable. How does an honest financial institution compete with a dishonest one that can have better annual returns, that can pay bribes and get good leases, that can pay bribes and get a business advantage? How does an honest company compete? The entire premise of all of the U.S. whistleblower laws, for which you will hear about and are in my handbook, are premised that unless you have strong oversight and unless you incentivize the detectors, the whistleblowers, the absolute essential source of information, the market itself will be corrupted. Bad behavior will be reinforced and honest people driven out. Yet with an effective oversight program and whistleblower program, you can have the opposite. Europe is asleep. I am angry at what I see in Europe. I am upset that I have so many European clients. And I am upset that the responses we get from the parliaments and the regulators have no sensitivity to whistleblowers. And I will concede, maybe I shouldn't, but I have never recommended a client go to a European law enforcement agency. Simple as that. You go to the U.S., and I'll explain how you can do it. The U.S. may bring the information back to the continent. That's the situation. Well, the whistleblower spoke to a lawyer. Not me, but when this was all happening while he worked there, the lawyer advised him to resign because of ethical problems, which he did. There were no employment issues. And eventually his name against his will was leaked to the press in violation of law, for which he has no recourse. The following quote is from a major study from the University of Chicago, Booth School of Business. This wasn't done by some whistleblower advocacy group. This was economists. Their conclusion was very favorable to incentivizing whistleblowers through rewards. But this is what they said. Honest behavior is not rewarded. Given the costs of whistleblowing, the surprising part is not that most employees do not talk. It is that some talk at all. How true. Then to the rescue. To the rescue. President Abraham Lincoln in 1863, at the height of the U.S. Civil War, when he realized that there was corruption within the Union bureaucracy in contracting, decided to incentivize whistleblowers. And he enacted a qui tam law known as the False Claims Act, still our #1 law. And he said, and this is what's incredible about these laws, and they're so misunderstood. This is a people empowerment law. He said to the people, and specifically going to employees, but to the people. And he said, if you have information, come forward. You will get a reward if it's proven true. And the key is the concept known as qui tam, which is in the name of the king. But in the United States, they used it, but it's in the name of the people. It's we the people. And it gave the whistleblower the power of the United States government. They could stand in the shoes of the government itself and file a lawsuit when the government was corrupted and wasn't willing to do it itself. This is a fundamental citizen empowerment law. This is not some strange thing, yet there's not a country in Europe right now that's even willing to consider this provision. I'm going to skip over some of the details. Let me just say it's a great law, and I'll come back to it. The law was modernized in 1986, and it allows the whistleblower to stand in the shoes and obtain a reward of 15 to 30% of the money collected in the fraud. Now, the government can pursue the case, and the whistleblower still gets their reward. But after 30 years of monitoring this law, it was modernized in '86, so we've had time to watch it. This is not idle speculation. All of the attacks on these reward laws in Europe are all speculation. This is based on concrete empirical evidence. So let's see what they say. So this is the former Assistant Attorney General who had responsibility over these civil fraud cases. This False Claims Act whistleblower law, this is key, is the most powerful tool the American people have to protect the government from fraud. The key phrase here is most powerful. Most. After 30 years of reviewing this concept, it was realized that by incentivizing the insider, those who actually know where the frauds are, you converted a theory, an idea, something that Abe Lincoln himself envisioned. It was a visionary law. And as implemented, it becomes the most effective tool. And as I like to say, the debate over whistleblowing is over. It is over. It doesn't matter if you love them, hate them, they're good or bad. It works. And it is the only thing that I have seen, and I've been doing this for 34 years, that works really well. So let's go see how do they know this? Why would this guy say, oh, it's such a good law? Because he has to. In 2017, the False Claims Act monetizes the effectiveness of whistleblowing. If the United States brings a case on its own without a whistleblower, it goes into a category, they figure it all out. If a whistleblower comes in, it goes into another category. Why? They have to pay an award. So every single fraud case, they have to evaluate whether it came in from a whistleblower. So they know to the penny how much money the whistleblowers are bringing in and how much money all the government people, the inspectors, the contract people, how much they're bringing in. And in 2017, it was 92% coming from whistleblowers. So when they said most effective, they're not blowing it. But there's another interesting statistic that I like. That little blue line. It shows the amount of fraud recoveries from the day they modernized the law in '86 till today. And what you see is an upward tilt. It gets better and better. More people know about it. And this doesn't catch the deterrent effect of the law. So what we know is from '87, when the first cases started coming in till today, whistleblowers were 72%. Now this is one, when you get a copy of my thing, you can read it a little better. This is a print out of the U.S. Department of Justice analyzing every single year since '87 of the False Claims Act, every penny collected. So the pennies that I like are the two circled. So the whistleblowers brought in $40 billion in sanctions. And here's what people don't really know. Look at the second circle. The United States government has paid whistleblowers under this law alone $6.5 billion. $6.5 billion. I will tell you right now, if you take every other whistleblower law in the world, throughout all of history, and add them up, you'll probably get to 25, 30, 40 million. Under this law alone, this does not include employment cases, does not include attorney's fees, does not include retaliation. Rewards. It's fundamental, groundbreaking. Given time, I have a lot of other good quotes. We'll just skip them, because we're going to get to the good part now. The international application of the U.S. whistleblower reward laws. So because the False Claims Act was so effective, other laws were passed modeled on it, covering tax, securities, commodities, Foreign Corrupt Practices Act, and in a 2008 amendment, unanimously passed just this year under President Trump and a Republican Congress, unanimously passed, expanding the IRS law to cover money laundering, to cover every form filed with the IRS, even if it has nothing to do with tax, including FBAR, FATCA, and covering every case that the IRS has jurisdiction to investigate. Why was it expanded? Because whistleblowing works. Because we can go to the Congress with documented evidence that this is how you do it. And it's nice that it's transnational. This is just some of the international companies or big banks that have paid sanctions under the False Claims Act, which primarily deals with government contracting. But don't think it doesn't have transnational application. So you can see Royal Dutch Shell, 110 million. You can see Deutsche Bank, 202 million, among others. You can see then Bank of America. It can get to the banks, $1 billion. We did some great mortgage cases on this. But let's go to the heart of what we're talking about here, money laundering, tax, and cash. The IRS's serious efforts on offshore tax evasion were brought to our attention by whistleblowers. Well, another understatement, the United States had no effective program to police offshore banking until they enacted the law in 2006 for IRS. Bradley Birkenfeld walked in 2007, and history was made. He got the largest whistleblower award in history, but it triggered other whistleblowers, many of whom I've had the honor of representing, from numerous Swiss banks and Swiss financial institutions, ending in over $16 billion collected in penalties, ending in my estimation, although no one has done this, I would estimate it at about $500 billion, $500 billion at least in capital coming back into the declared economy. 50,000 Americans voluntarily admitting they engaged in tax evasion. So we can, the PowerPoint has a lot more information, so I hope you get it. Then you hit the Foreign Corrupt Practices Act. Many of you may know what this law covers. It has broad transnational application. So I'll just summarize it from the whistleblower perspective. Any foreign national can file in the United States anonymously a claim on bribery. That claim can be predicated on a bribe paid outside of the United States, by the bribe paid by a non-U.S. person, paid to a government official non-U.S. And that whistleblower can have full confidentiality, full anonymity, and fully entitled to the reward, as all of these laws are transnational in impact. Between 2011 and fiscal year 17, last numbers we have, 2,600 whistleblowers from 113 countries have filed these claims. Let no one tell you that these reward laws are somehow unique to America. There is a thirst for honesty, just like Howard Wilkinson. He wanted to see things done right, and there's a lot of people who want to see things done right. They just don't have a way to do it. This door opened. There's been very little publicity of the Whistleblower Program, by the way. Most of my lectures, most people don't even know. I don't know how these 2,600 people learned of it from 113 different countries. And that's it. As of 2017, all the countries in red, that's where whistleblowers have come in, I would say almost overwhelmingly anonymously. This is an example of the broad extraterritorial jurisdiction that can be reached. So let's just find the quote. Don't believe me, you can believe this guy. Kevin O'Neill, Deputy Secretary of the SEC. You file with the SEC, but you collect for DOJ, SEC, the works. Here's his quote. Now, this quote is applicable to the IRS, to the DOJ, to the SEC. All of our laws are extraterritorial in nature. It makes no difference whether the claimant was a foreign national, the claimant resides overseas, the information was submitted from overseas, or the misconduct comprising U.S. securities laws occurred entirely overseas. They have paid well over $30 million under this to foreign nationals already, making it the most successful whistleblower law outside of the United States, just by $30 million. Now, the Securities and Exchange Commission also has a whistleblower law for all securities violations. And I like just to emphasize things, and it's not that the money is everything, but it's real, it's objective. The reason the money is objective, because believe it or not, the United States won't just be handing out checks to people. You have to work for it and prove it. Your information has to be of high quality, leading to a successful investigation. It's not a giveaway program at all. It's tough. You should hire a good lawyer to get it. But this just shows you some of the top 10 awards the SEC has paid since this law was implemented. And you'll notice some of the biggest were all paid in 2018 under the current administration. In other words, these systems are operational, and they have strong bipartisan support. I just want to go to the Commodities Futures Trading Commission only because a lot of people don't understand it. It's a relatively new law, and they've now awarded the first foreign national under that law in 2018, and the commission publishes sanctions for which there's whistleblower eligibility. The granting of these awards, for the most part, is completely confidential. Nobody knows who the whistleblower was or what company they blew the whistle on. It's all secret to keep confidentiality. But they do publish the cases for which whistleblowers are eligible. And these are some of the cases the Commodity Futures Trading Commission published to let whistleblowers come in. And you'll see they have jurisdiction over things like foreign exchange and others. Coming back to the Booth School of Business, University of Chicago, as I like to say it, not the most whistleblower-friendly institution in the world. But they studied it. They were really smart. They studied for a specific period of time every single major fraud case. With the point of view was, how was it reported? Who are the detectors? Were they the journalists? Were they internal compliance? Who did it? And in that study, which was comprehensive, their conclusion was quite simple. A strong monetary incentive to blow the whistle does motivate people with information to come forward. Is that really hard? Then it gets to the next point. Monetary incentives seem to work well without the negative side effects often attributed to them. All this nonsense I hear in Europe about why these are all bad ideas, it's all speculation, it's all nonsense, and it's all been disproven. They work well, and they don't have these negative side effects. And then their final conclusion, which is what was set up in the front, employees clearly have the best information. I'm going to come back to that in a second, but I love this. The final quote is from Chuck Grassley, chairman of the Senate Judiciary Committee, and he's essentially an expert because he has monitored these laws from 1985. He's on top of them. He knows them intimately. Empowering these whistleblowers to prosecute fraud proves to be smarter, faster, and more effective than just relying on the government. No offense to the government, they do a good job often. I just want to come to one other point, which is these non-disclosure agreements that are rampant in Europe that absolutely prevent information from going to parliaments, from going to regulators, that employees often have to sign. I will presume that all the employees at Danske Bank have had to sign something like this, which means how will anyone ever learn the truth if all the witnesses are gagged? In the United States, they're all outlawed. You can never get away with this. And I'm just going to point to 3 provisions of law that are applicable. Dodd-Frank Act, Foreign Corrupt Practices, so that's Commodities, Securities, FCPA. Not only are NDAs that prevent employees from going to any governmental entity to blow the whistle about possible crimes or to go to Congress, not only are they prohibited, they are considered a securities violation on par with insider trading. The SEC has actually sanctioned corporations for securities violations just for having an NDA that restricts the flow of information. My favorite, we'll hit Defend Trade Secrets Act. As I like to say, you abuse it, you lose it. So companies say, oh, you can do whatever you want, but you can't release a trade secret. And then they broadly define trade secrets. Well, thank God, Congress, again unanimously with broad bipartisan support, amended the Trade Secrets Law to say whistleblowers can bring any information deemed a trade secret to every police department in the country. And they can use it in their retaliation cases. So when the companies tried to use trade secrets to hide their crimes, Congress responded appropriately. Finally, obstruction of justice, which is what it all is. 2002 Sarbanes-Oxley Act, they looked at obstruction of justice to go beyond just beating up a witness or blowing up their house or giving them poison on the streets of London. And they said that if you interfere with the livelihood of any person, comma, including their employment, but it's livelihood, because they gave truthful information, so you can't be a fraud, about a possible crime, didn't have to prove it, to law enforcement. If you do that, it is a felony, 10 years in prison. They criminalized retaliation. That does not exist in Europe. Believe me, I know that through the Danske Bank case. We asked permission from Danske Bank, which is insane. Okay, that's my prepared remarks. I just want to give a little boost. I did bring some for review copies, but the Whistleblower's Handbook, it's all in here. The rules that cover transnational, I highly recommend it. I would have brought more, but they were just too heavy, so I apologize for that. I would like to have given one to everybody. So thank you very much. I'm open for questions. Thank you. Yes?
Tell us something about your presumably not very successful relationships with British authorities over whistleblowing. The situation really here is that whatever laws are in existence are very rarely put into operation. So that one of the big whistleblowing areas is the National Health Service. And various nurses and other people have tried to give information. They've been victimized, they've lost their job, and effectively very few people have come to their aid. So I'm quite interested in the reaction of the British authorities to when you try and tell them that they need to change the law.
Sure. So, and it's a great question because it leads to another. It's one of the rules in the handbook. I have a rule that's called follow the money. And essentially what it says, and it's my belief, that most people aren't born evil, but greed does seep in, and behind most whistleblower cases you can usually find some form of profit mechanism. And so many of these new whistleblower laws target that. They target the financial side of the misconduct. So under our False Claims Act, the single largest amount of recoveries come from our National Health Service, which is the Medicare and Medicaid programs. And it covers everything from lying about medication to abuse in nursing homes to giving people bad operations when they don't need it, and a variety of other crimes and misdemeanors. So the lawyers very successfully, because there was government money involved, adapted it. I will also state that the United Kingdom's Bank of England Prudential Regulatory Authority issued a report on whistleblower rewards. It was requested by Parliament. We wrote a rebuttal. It's easy to get. I'd provide it. The report was full of misstatements. I could say outright lies. It was shockingly deceptive. And from that point on, I just pretty much have nothing to do with any law enforcement agency in the UK, no offense to the good people who are probably doing a great job. The US laws are supersonic. They give my people anonymity, confidentiality, so if nothing turns up, the best protection against retaliation is that no one knows who you are. They reward you, not because you suffered, not because you were fired and driven into unemployment for years or forced to live in a car, which I've seen many times. They compensate you based on the value of your information, and nothing could be better than that. So these are supersonic laws that I urge all of my European clients to utilize. So I hope that answered the question. Sir, I think you had your hand up. Yeah?
Thank you very much. Ewan Grant Institute for Statecraft. I've seen when I was working in the UK Customs Service the need for greatly beefed up internal protection for the reporting of wrongdoing, even if it doesn't come under whistleblowing because it's not going outside. One person who would be able to confirm that when he retires is the present head of our security service, Mr. Andrew Parker, because he was one of the men who was brought in from the security service to sort the shenanigans out. And one of the key successes in sorting it out was he made it clear to staff that he was going to do that, and old ways were no longer going to be tolerated. My question around Danske is, I know it's early days yet, are you able to say something about how you perceive the current responses we're getting to this in the European media to the reported criminal investigations, and particularly the announcement that Danske will make large sums available to fund investigatory and regulatory procedures. The thing that would really worry me at the moment is something you mentioned right at the start in Howard Wilkinson's initial report, that this isn't Mexican drugs gangs. This is the Russian deep state, and that needs a rather different response, which is not entirely one for law enforcement alone. Thank you.
Sure. As I said, that we didn't intend or want Mr. Wilkinson's name to come out. Unfortunately, he'd gone internally, and many people at the bank knew who he was. It's just hard to say. The case is flowing. We'll see where it goes. I view these cases on two levels. One, representation of a client to use the laws that are available to his best interest. Two, we are very concerned about systemic reforms and strongly believe in using our experiences and expertise to try to get structures in place to fix the problem. So that's that, and I appreciate your comments. Yeah? There's my card.
Well, actually, I'd represent myself because David and I represent whistleblowers. I'm a former AUSA, so I used to prosecute them with DOJ. One of the things, great presentation, by the way.
Thank you.
But one of the things that I think you should share with our European friends is that, as you know, there's usually a parallel track or potentially a parallel track with the civil whistleblower. There's also another federal prosecutor, there's another AUSA, there's somebody from the FBI that could arguably put the handcuffs on somebody, which I think is a beautiful thing. Thank you.
This is a very good point. So as our laws have developed, as I say, they've become supersonic. So let me just describe foreign corrupt practices and also the tax law now with the amendment, because it combines rewards for civil and criminal. But the way that Dodd-Frank works, which is securities, commodities, and foreign corruption, if the SEC or Commodity Futures Trading Commission sanctions a company or any one part of the broader conspiracy, that's part of the core element, $1 million or more, collectively. So if 10 people each have to pay $100,000, it triggers a related action provision. If you filed your claim right, you can then obtain a reward for every single civil and criminal case related to that case. In other words, it's supersonic. It's the Congress, when they were crafting these as it moved forward, was trying to fill loopholes, make them better. So you're 100% correct. The criminal cases often drive the civil cases. The FBI and the DOJ often do the lion's share of the work and do a fantastic job. But as the laws have developed, now the whistleblowers can share in that.
You mentioned the PRA report, that was full of flaws and falsehoods, I think you said. Can you be a bit more specific about what you specifically found false with it? And,
Sure.
Perhaps generalize, if you could, about British or European attitudes to the problem.
Someone told me a British word I should use for it. I have some US words that aren't very kind. So the first thing they do, they come right out and say, we met with the US regulators and all of them said that the laws don't work. Well, I've met with the people who implement those laws. I work with them all the time. They love them. On these quotes, I could literally gone for 10 hours on documentation and quotes. Who did they talk to? This is not true. And then I read their footnotes. Oh, we spoke to the United Nations. Oh, what? They don't give out rewards. Oh, you traveled all the way to New York to meet with the UN? And then they said, oh, we went to the SEC. which I found not believable because I know what the SEC was saying and doing. They loved it. And 2 years later, an article appears in the paper from the former director of that office. He says in the newspaper, oh, I told him it was great, and I invited them to stay and watch how we work. It's such a great program. And they got up and left. That's just the beginning of it. The whole thing was like, it just wasn't truthful. So we did write a rebuttal. We sent it to the Bank of England and the Prudential Regulatory Authority. They said they're going to respond. 2 weeks later, they write some letter that said absolutely nothing, like we wrote a report and we read yours. So they didn't rebut one thing in our report. But it showed a systemic hostility, which we see all the time, unfortunately. So the United States has some great laws. There's still a lot of hostility. Hostility to whistleblowing is embedded culturally in many institutions, government and non-government, and unfortunately, it's embedded in that regulatory agency.
Thanks. It's Caroline Binham from the Financial Times. Bradley Birkenfeld spent time in prison, even though he got a reward. So the process isn't entirely without risk. So could you perhaps speak to how you advise your clients whether it's worth taking that risk and going forward?
Sure. And I had the honor of, like I said, representing Mr. Birkenfeld, so I know what happened in the case. So Mr. Birkenfeld was a pioneer. He was one of the first to file an IRS case. But he made a fundamental error. And I say that's why you need to follow the law, follow the procedures, do it right. He walks into the prosecutor's office, not the whistleblower office. He walks into a prosecutor's office. What do they do all day? They prosecute tax frauds. Without any immunity, he sits there and admits to tax fraud. He was a banker in Switzerland. Well, I'm a banker in Switzerland. I have all these clients, and I travel to the United States, and isn't this terrible? And I'm sure the prosecutor was saying, oh, yeah, it's terrible. I own you. You just admitted to everything. So, totally crazy. So then things went downhill from there, and he got charged and convicted. But here's the trick. The U.S. whistleblower laws 100% protect participants. If you are the planner and initiator, you're out. You're the bigwig. I've never had a planner and initiator come to me. But all of these frauds have participants, whether they're the guy that drops off the bribe, a banker with illegal accounts. Danske Bank had hundreds probably of participants, all working on their laundering scheme. And what we understand in our law is that the participant is the key. The participant will have the best information. In 1863, when the original law was debated in Congress by the radical Republicans fighting to save the United States democracy and abolish slavery, the senator from Massachusetts stood up and said, we're going to do this law because it takes a thief to catch a thief. We need to get people from inside the conspiracies to come forward. So, as I understand, in the 30-year history, in the thousands of cases, there has never been a prosecution of one of these whistleblowers, but for Birkenfeld. He's the only one ever who was convicted of a crime and got an award. It just doesn't happen. If you use the laws correctly, they love you. You're their best witness. That case went awry, unfortunately. It was new. It won't happen again, I don't think. So I probably answered that question, yeah?
Can I just ask a question about something that I feel strongly about, and which is a common thread throughout conferences like this, namely the role of the watchdogs, the auditing firms. Just out of interest now, I just Googled who were the accountants for Danske Bank, and I'm reading here an article from a few weeks ago from the Irish Times. Between 2010 and 2014, it switched between Grant Thornton, PwC, KPMG, Deloitte, and EY. What have you found with regard to any whistleblowers coming from auditing firms? And what do you see happening with regard to the attitudes of the auditing firms, not just in Europe, but Could we just widen the scope and see, do you have any experience, for instance, from Asia?
Yeah. Okay, great question. So first, some of my best clients have been in compliance. They know where the skeletons are, and they're fully protected. So the False Claims Act and the IRS law, you can be an auditor, you can be a compliance official, you can come in. Now, if you have certain confidential information that's actually protected under law, the government will put up what's known as a taint team and screen information that might be attorney-client privileged or covered under some other privilege. But mark my word, the vast majority of information will come in, and there is a crime-fraud exception, even to some of these stricter privileges. So if you are in an auditing or even in an attorney capacity, you can still blow the whistle. You just have to go a separate route, which is making sure the lawyers you work with, and as you do it, identify information that might be privileged under any law, and then make sure it goes to a taint team. But let me tell you about auditing, and it's in the handbook. I have these numbers. I have a couple charts. And I can't find one of them, which I know I have somewhere. But in a comprehensive survey of auditors by the National Association that represents auditors, whatever their name is, you may know it, they found that 55% of chief auditing executives were directed to omit important findings from their reports. 55%. This was a survey of 14,000 auditors from 166 countries. It's on page 227 of the handbook. 49% were directed not to perform audit work in high-risk areas. And who was making these directions? The mob? The crook on the corner? Chief Executive Officer, 38% of the time. Operations Management, 25%. Chief Financial Officer, 25%. These were directions from the top in the majority of audits. When we fought the Dodd-Frank fight over that law, Wall Street came in and they said you must exclude from these whistleblower reward provisions auditors and compliance and the audit committees, because they're paid, they're our army to find the misconduct. And it was a good argument. It almost won. It sounded good. Until I dragged up a chief compliance officer from a large multinational corporation to meet with every commissioner to say what was really going on. And we showed him the cases, how compliance officers were being retaliated against. So compliance officers are protected. There's special rules for them. They're in, as they should be. They're often in the front line of retaliation.
Stephen, hi, Mary Inman from Constantine Cannon. I'm heartened by the fact, and I think it's telling that the number of U.S. lawyers in the audience today are people who are U.S. qualified, who are trying to bring people from England and the EU to the United States. So I think that's pretty telling that I think people, Europeans, and your figures bear that out, want to be using U.S. programs. But my comment was that I don't want everyone to be completely disheartened with what is going on in the United Kingdom, because I think a lot of people may not be aware that there is now what was convened in this summer an all-party parliamentary group on whistleblowing. They just started to take testimony last week. It is a bipartisan group, and the purpose of it is to look at the Public Interest Disclosure Act, which is the whistleblower protection law here, which is 20 years old, and there seems to be a consensus is no longer fit for purpose, and that they're considering things again. So I'm hoping, I recommend people to go on the APPG website and participate and fill out the survey, but I'm hopeful that we may be able to get change.
And I want to say I'm actually meeting with Member of Parliament tomorrow, and we are urging the UK to fix their laws. And I hope that people review our critique of the Bank of England report, because there was some support in Parliament to really modernize these laws. Don't wait to 30 years. None of the laws I used when I started practicing law in 1984 do I use today. They were fixed slowly over time. Took 30 years. Don't wait 30 years. Study what we have done and model it. The UK is an advanced democracy. It can do it tomorrow. There's a lot of misconceptions. So, anything, and we can chat after. We are, as I say, we're very involved in public policy and would love to see UK get it right. I think there's time now for one more question, then I'm available after if people want to come up and chat. So can we have the last question of the day, right? I think this is my time, right? 1 hour? We're done? Yeah. Correct? Okay. So is there one last question? Going? Going? Thank you all very, very much. Thank you.